This video is made for educational purposes only and cannot be taken as legal advice. Always remember, knowledge is power. In this video we are going to take a look at a passage from a Supreme Court judgment that I personally think is extremely relevant to the police crime sentencing and courts bill. So you have a better understanding of why I think this is extremely important. If you have ever been in court, you may have heard your barrister or solicitor quote a passage from a previous court judgment as part of your defense. A barrister will draw on a whole raft of different judgments to formulate his argument, which will go to strengthening your defense. And now we will take a look at the relevant passages from the judgment citation number 2002, EWHC 195, admin. As Lord Justice Laws states at Part 60, with which Lord Justice Crane agrees. The common law has in recent years allowed, or rather created, exceptions to the doctrine of implied repeal, a doctrine which was always the common law's own creature. There are now classes or types of legislative provision which cannot be repealed by mere implication. These instances are given, and can only be given, by our own courts, to which the scope and nature of parliamentary sovereignty are ultimately confided. The courts may say, have said, that there are certain circumstances in which the legislature may only enact what it desires to enact if it does so by express, or at any rate specific, provision. At Part 62 he then went on to state, where does this leave the constitutional position which I have stated? Mr. Shrimpton would say that factortame, number 1, was wrongly decided, and since the point was not argued, there is scope, within the limits of our law of precedent, to depart from it and to hold that implied repeal may bite on the ECA as readily as upon any other statute. I think that would be a wrong turning. My reasons are these. In the present state of its maturity, the common law has come to recognize that there exist rights which should properly be classified as constitutional or fundamental. See for example such cases as Sims, 2000, per Lord Hoffman at 131, Pearson v. Secretary of State, 1998, Leach, 1994, Derbyshire County Council v. Times Newspapers Limited, 1993, and Witham, 1998. And from this a further insight follows. We should recognize a hierarchy of Acts of Parliament, as it were ordinary statutes and constitutional statutes. The two categories must be distinguished on a principled basis. In my opinion, a constitutional statute is one which a. conditions the legal relationship between citizen and state in some general, overarching manner, or b. enlarges or diminishes the scope of what we would now regard as fundamental constitutional rights. A and b are of necessity closely related. It is difficult to think of an instance of a that is not also an instance of b. The special status of constitutional statutes follows the special status of constitutional rights. Examples are the Magna Carta, the Bill of Rights 1689, the Act of Union, the Reform Acts which distributed and enlarged the franchise, the Human Rights Act, the Scotland Act 1998 and the Government of Wales Act 1998. The ECA clearly belongs in this family. It incorporated the whole corpus of substantive community rights and obligations, and gave overriding domestic effect to the judicial and administrative machinery of community law. It may be there has never been a statute having such profound effects on so many dimensions of our daily lives. The ECA is, by force of the common law, a constitutional statute. And at Part 63 he then says, ordinary statutes may be impliedly repealed. Constitutional statutes may not. For the repeal of a constitutional act or the abrogation of a fundamental right to be effected by statute, the court would apply this test: is it shown that the legislature's actual, not imputed, constructive or presumed, intention was to effect the repeal or abrogation? I think the test could only be met by express words in the later statute, or by words so specific that the inference of an actual determination to effect the result contended for was irresistible. The ordinary rule of implied repeal does not satisfy this test. Accordingly, it has no application to constitutional statutes. I should add that in my judgment general words could not be supplemented, so as to effect a repeal or significant amendment to a constitutional statute, by reference to what was said in Parliament by the Minister promoting the bill pursuant to Pepper v. Hart, 1993. A constitutional statute can only be repealed, or amended in a way which significantly affects its provisions touching fundamental rights or otherwise the relation between citizen and state, by unambiguous words on the face of the later statute. And at Part 64 he then says, this development of the common law regarding constitutional rights, and as I would say constitutional statutes, is highly beneficial. It gives us most of the benefits of a written constitution, in which fundamental rights are accorded special respect.